The question over where you can and can't park can be a confusing and often frustrating one. One motorist who ignored 33 tickets he received at a Glasgow car park has agreed to pay almost £3,000 in unpaid fees. He reached an out-of-court settlement with a car parking company after CCTV cameras caught him repeatedly flouting a 2-hour parking limit. Well, it's been reported that the man ignored dozens of penalty notices because he believed they were unenforceable in Scotland. So where does the law stand when it comes to parking charges? Let's speak to Patrick McGuire, a partner at Thompson Solicitors, and Mike Perkins, an operations manager of Combined Parking Solutions, the company which issued the penalty notices at the Glasgow car park. Good morning to both of you.
Morning.
So there does appear, gentlemen, to be a lot of advice, perhaps not good advice around online particularly as to whether or not parking penalties can be enforced here. Patrick McGuire, let me ask you what the truth is of that.
Well, the law is actually, as it's always been, I know there's been a lot of grand statements made about a House of Lords Supreme Court decision recently called Beavis, and of course an awful lot was made of what happened yesterday. The reality is that the parking debate is one where, as you said, there's always been grand statements. At first, consumers were saying that you simply ignore these documents, they're unenforceable in Scotland. That's not actually true. But similarly, I understand after yesterday's decision, the word was going out that now it's proven beyond all doubt that every parking ticket is enforceable and you have no choice other than to pay. That's also not true.
So what would be the exceptions?
It comes down to the fact, as the Supreme Court case showed 3 or 4 months ago, that this is a question of contract law. The issue is that often these penalties are presented in a way exactly like that they are a penalty issued by a local authority or perhaps the police. That's not the case. So because it's an issue of contract law, it's down to the parking company to be able to prove, firstly, there was a contract, and secondly, with whom they contracted. And it's up to them to prove all of these things. If they can do it, they're certainly entitled to enforce it. That point is clear. But if they're not able to prove both of those points, and crucially, who actually they entered the contract with, then they simply are not entitled to their money. And that's actually the crux of the matter.
So, Mike Perkins, just on that point, does that mean you have to prove who was driving the car to enforce the penalty?
Okay, firstly, they're not penalties and they're not fines.
What are they then?
They're parking charges, and we're always very careful, never ever, to dress them up as penalties and never use those words. In relation to who has to pay the charge, well, yes, it is the driver, and the law in England and Wales is slightly different because we have a bit of legislation under the Protection of Freedoms Act. But in Scotland, we have to prove who the driver was. But remember, this is the civil burden. It's not a criminal. We have to just show on the balance of probability who the driver was. Now, we contact the registered keeper if the charge is not paid, and we give the keeper the opportunity to nominate the driver because we only ever want the driver. There are various cases, again, in England and Wales, which state that generally, under the civil burden of proof, the keeper is normally presumed to be the driver unless they can prove otherwise. Now, you could go in front of one sheriff and he or she could accept that that the keeper was the driver because they refused to name who it is, and you could go in front of another sheriff who could take a completely different view. But again,
so this would be a civil case taken against a driver.
Most definitely. And so, as I say, the civil burden is 49-51%. But we always go along the argument of, if you were to receive a ticket, the registered keeper gets a letter. If they weren't the driver, why would they want to go through all the hassle of appearing in court and dealing with debt collection letters, etc., when simply they could just say, I wasn't the driver, contact so-and-so, and the matter's dealt with.
Yeah, well, it might be a member of the family, and that mightn't be as, people mightn't be as willing to do that in reality.
And there's a lot more fundamental point here, which is Mike suggested that they never present these fines as anything other than a parking charge, and yet in his comment a second ago, he was straight to suggesting that drivers ought to nominate who the other driver or who the other person was, and indeed suggesting that there is some form of legal obligation to do so.
And in
Scotland, that is absolutely not the case. So to come back to the point, when you get a document through the post saying where are you driving, why would you not say who the other person was? A, you might not know, but B, and law, you're not required to do so. What you're entitled to do is to say to the parking company, you tell me what evidence you have. You tell me how you suggest you're going to prove who was driving. And certainly my experience of these things is that those letters go ignored. That doesn't necessarily become an end to the matter. Sometimes it is escalated straight to court. What I would say to Mike is, if people are asking you for the evidence that you have, if you want to be fair, if you want to be open, show them the evidence. That's the fair and appropriate way to act, I think, in this circumstance. It's certainly what the law requires, and it, I think, would bring a lot of these disputes to a far quicker resolution. And if you don't have the evidence, don't pursue it any further.
Well, unfortunately, various sheriff's courts up and down Scotland disagree with that, and we've been involved in many cases where we've gone to court and the sheriff has decided on the balance of probability the keeper has been. But as I say, I've never suggested there's been any obligation. I've said we send a letter, and with that is a form to complete. You are correct, there is no obligation to do so in Scotland. However, we reserve the right to take the keeper to court on the balance of probability, and then it's up to the sheriff to decide.
And because your cost base are so low, you try and keep them so low, you simply issue standard letters all the time. And that means if somebody, as I've suggested, writes to you and says, what's your evidence? You don't engage in individual correspondence. In each of those cases you've spoken about, I could almost guarantee you'll have sent standard letters, you won't have produced any evidence at all, and the next thing the poor member of the public will have received is a summons being served upon them. That's just not inappropriate. If you have the evidence, show it, and don't rely on presumptions.
Okay, let him respond to that. Mike Perkins?
Yeah, I think you've made a generalisation. I mean, we've never dealt with you. We don't send standard letters. Other companies may. I can't comment on that. If somebody asks us for evidence, we send it. We have no problem, because we'd only have to send it.
And what would that evidence be, briefly? Would it be a CCTV of the driver of the car or something?
In many of our sites in Scotland, because we don't have the Protection of Freedoms Act, we do have CCTV, as we did in the case a few days ago. If we don't, we send photographs of the vehicle, which sometimes don't have the driver, and then it is down to the individual what they want to do. They could turn around and just say, put their head in the sand and say, I'm not telling you, and then it will proceed to a sheriff's court, and the sheriff can make the decision. OK,
well, we'll have to leave it there, gentlemen. Thank you both very much for discussing the issue with us this morning. Mike Perkins there from Combined Parking Solutions, and Patrick McGuire, a partner at Thompson Solicitors.